Good morning and a very warm welcome to all of you to this edition of Eurofound Live. Today's hour-long webinar will focus on one of the topics that has been most in the spotlight at the moment in the policy debate, that is both at EU and at national level, the issue of platform work. We're going to be looking at what this is, who are the workers involved in the platform economy, where do they work, how do they work. We'll look at the challenges that are associated with this new form of employment, but we'll also try to explore the potential opportunities. And most importantly, how do we get to a place where those aspects are reconciled or regulated effectively? We have to consider the variety of initiatives that are at play at national level, the diversity of experiences, and the different opinions that are at play among the numerous partners that are currently ongoing. Today's webinar really could not be more timely. We are right in the middle of a legislative process where we have a proposal on the table from the European Commission, which is currently being negotiated in the European Parliament. The Parliament has planned to adopt this opinion over the next month, but the discussions are very intense, as you can imagine, and there has been no clear date set. At the same time, very recently, the Czech presidency has just put forward a text with proposals for possible derogations on the employment status, which could be introduced to the Commission's proposal. And ETUC, which is one of our panelists today, as we saw earlier this week, have reacted to this proposal. So we are living indeed in very interesting times, and we will be hearing about all of this and much more from our fascinating guests today. I'm now delighted to welcome and introduce them to join us. So firstly, we have Dragos Adkolicki, who is Eurofound's expert on platform work, and he's a researcher here in our employment unit. Good morning, Dragos. We're also joined by Willy Ledenwirte from the Oxford Internet Institute at the University of Oxford. And we have Ignacio Doreste, who's a senior advisor from the European Trade Union Confederation, the ETUC. And we have Isaline Osieux, who is an advisor with Business Europe. So you are all very welcome to our webinar this morning. But before we start, I'd like to make a few practical announcements. This webinar will be broadcast live on our YouTube channel, on Twitter, and on Facebook. Our website is eurofound.europa.eu, and this webinar is also being recorded. Those of you who have registered on our online interactive platform Livestorm, only you can actually send in questions via the live chat, and we will address those during the Q&A. The recording will also be available on our Eurofound website and on YouTube shortly after the event. As always, though, we do hope to continue the debate online, so feel free to share what you hear and see on our social media channels using the hashtag Eurofound Live or hashtag platform work. So, opening up and to start us off in this big debate on EU's Big Balancing Act, Dragos, can you start us off to set the scene? Can you tell us why platform work has taken on so much importance over the recent time? Who are these platform workers? What do they do? How many are we talking about? And what are the real issues associated with platform work, the protection of workers, and what is at stake for employers in this new form of employment?
And good morning, everyone. It's a pleasure to be here, and it's a pleasure to be in this panel with so many interesting co-panelists. I would start by introducing a couple of stylized facts about the platform economy. And the first point to be made is that platform economy is here to stay. Since about 2015, the year when the platform economy has reached a more or less critical mass in Europe, we have witnessed a continuous expansion of platform work in terms of its geographical reach. So more countries using platform work, in terms of business models, in terms of the number of workers who provide work to platforms, as well as in terms of the amount of revenues that platforms themselves derive from this type of work. So in other words, what we've seen in recent years is that the pervasiveness of platforms in our societies has increased substantially, not least because of the COVID-19 pandemic, which has provided the boost to platform work. In a much, let's say, in a broader sense, the expansion of the platform economy is also linked to a move towards using digital technologies to organize and manage work, as well as with the emergence of new business models. So platform work is, in a sense, a symptom of a broader change that we witness in our labor markets that sees an increased use of technologies to manage and organize work. Now, looking a bit at the scale of platform work in Europe, the first point to note is that data around how many workers are engaged in platform work remains relatively scarce. We have various estimates by different institutions and research institutes that vary depending a bit on the methodology used and the kind of the sample of countries included, as well as the type of platform workers which are surveyed. However, what we know more or less is that an estimate of the European Commission suggests that around 28 million people work through platform more or less sporadically. And that this number is predicted to increase in the coming years by about 43 million people. Now, that's a large swath of our labor force in Europe. So it's 43 million people is more than the amount of people that we currently work in the manufacturing sector. So platform work, in a nutshell, is a very important phenomenon that we should pay attention to. Now, it's also important to note that these numbers should be qualified in light of the level of income that workers derive from platform work and the number of hours they spend while doing tasks on platforms. So from this point of view, a more conservative estimate that we have based on the Colim surveys is that about 1% of the working age population in Europe, or about roughly 4.6 million people, work on platform at least 20 hours per week and receive or get at least 50% of their income from these platforms. Now, looking at the profiles of platform workers, this is where the story becomes also very interesting, because in general, evidence demonstrates that platform workers tend to be younger and more educated than the general population. Platform work also traditionally tends to be carried out more often than men. However, what we see in recent years is that we witnessed a steeper increase in the number of women who enter platform work, which replicates longer term trends that we see in the traditional labor market, with women kind of entering in larger numbers in the labor market. This also has to do with the expansion of platform work in traditionally female dominated sectors, such as care or translation services, for example. Also, what we know about the engagement of women in platform work is that they tend to live in households with dependent children, and they tend to be responsible for these children. So this is already points out that the double burden of doing work in the labor market and caring for household tasks is something that platform work replicates to a certain extent from the traditional economy. Also, in terms of the socio-demographic profile of platform workers, what we can see is that the much higher proportion of foreign-born workers provides services via digital labor platforms. than native workers. So here, in a nutshell, what we see is that a large section or a large number of migrants do engage in providing work via platform, which is a very, very interesting point to further discuss in this seminar. Now, why there are so many workers engaged in this type of work? Because it's a relatively new phenomenon that has caught up very fast, as I said in the beginning, and that is predicted to increase and to both in scale and in reach in the coming years. The main promise that platform work provides is the promise of flexibility. Yeah, that you can perform work whenever you want, at the pace that you want, and with you choosing, for example, the tasks that you want to perform. At the same time, platform work holds a promise of access, right? So whereas traditional or offline labor markets have certain barriers for particular categories of workers, migrants being one of them, platform work provides the opportunity to these workers to engage, perform work, and gain an additional income, or actually gain their main income by providing work on platforms. The promise of flexibility, however, needs to be contextualized. And this is a very important thing that relates to the discussions that we have nowadays around the regulating platform work. And that needs to be contextualized, because once we try to zoom in how work is organized via platform, this is the amount of flexibility that workers have depends very much on the level of skills that the worker possesses. So whether you're doing a very highly skilled tasks versus tasks that uses only very basic skills impacts on the amount of flexibility that you have in performing tasks, in performing your work. Depends very much on whether the work is performed offline or online. So we know from research again that offline work, so for example, your taxi drivers, your couriers, do not have as much flexibility as they want. And it depends also on the use of algorithmic management by systems, by platforms themselves. So it depends whether the platforms use an algorithmic system to manage, direct, and control the work that workers perform on platforms. And specifically, the use of algorithmic management systems has tremendous or huge consequences for working conditions. It has consequences in terms of the flexibility, as I said, that the workers have, in terms of the intensity of work, in terms of their engagement with the platforms, because we know that there exist cases when, for example, workers have been completely disconnected from the platforms if they refuse to perform tasks. It overall, the use of these systems has an impact on the well-being of workers in general. So what do these issues suggest? They basically suggest that we need to kind of address them from a regulatory point of view. We need to kind of try to think how to better regulate, or how to kind of try to solve the issues raised by platform work. Before describing a bit the directive, I would just note that this is not a novel discussion. Ever since the emergence of, or the appearance of platform work in Europe, we have seen that there have been attempts to regulate platform work by trade unions, by governments, by platforms themselves, which have also come with their own initiatives to address some of the issues that have emerged around platform work. So where we are at the moment is that in Europe we have a host of national initiatives that try to address the issue of working conditions and employment of platform workers. However, what we see from these initiatives is that they remain relatively fragmented. They concern very few platform workers, so they present effectiveness issues when it comes to the reach of platform workers, and they are very difficult to monitor. At Eurofound, we have a platform work repository where we have around 270 such initiatives that we have found that try to address the issue of working conditions of platform workers. Now, in response to this and building on this body of initiatives, what we have now at the European level is the European Commission taking an initiative and proposing a directive to address the issue of employment status and working conditions of platform workers. The directive, I will not go very much into it because I think we will talk a bit about it later. Just to say that it doesn't come out of nowhere. That it is built on the body of evidence and court rulings that we have seen emerging in Europe in the past years, and that it tries to, let's say, have, as we suggest in the title of this webinar, it's a balancing act between trying to address the key issue of employment status of platform workers, and through this entry point to improve the working conditions of platform workers. Thank you.
Thank you, Dragos. Now, that's a good scene setting, and I think what you have touched on there is the level of heterogeneity that there is at play in terms of the type of workers. A huge volume of workers. I mean, you're talking about over 40 million as the estimate. That's a large number. Increasing input of women, which and the Gender Balancing Act is also at play there. As you say, it's replicated. But I think also the migrants. And I mean, I know there's been an awful lot of research going on across Europe on this particular new form of employment. And maybe we can pull in here Billy, who will be able to give us some idea here as to the kind of academic research that has been doing sort of a deep dive into the platform economy. What lessons can we draw from this kind of recent academic work? Are there other issues that Dragos has not mentioned that should be considered as we have this debate about the future of the platform economy?
Thank you very much, Mary. So Dragos provided an excellent overview, I think, already of the issues, the need for regulation, as well as all the complexities around the topic. So I will just constrain myself to, as you suggest, to providing a little bit of sort of color on some of the issues from research. I've been studying platform workers for many years, especially online platform workers, online freelancers, and my many colleagues around Europe, they've done a lot of research on different types of gig workers, delivery workers, and so on. And as Dragos mentioned, obviously it's a very diverse set of circumstances, diverse set of people. We sometimes in research we use the word heterogeneous. That is a very heterogeneous workforce. And the platforms themselves, of which there are hundreds in Europe, although most of the work is concentrated on just a handful of large platforms, they also vary very much in their design. And so we have people like students who value the flexibility of platform work very much. And then we have people like immigrants who value the low entry barrier, but also desire greater predictability and protection for themselves. So they're very diverse interests among the platform workers, and sometimes these interests are even in conflict. As an example of such conflict, a few years ago there was a court decision in Amsterdam which effectively turned some platform work from self-employment into regular employment. And Professor Niels van Doorn from University of Amsterdam looked at the workers' reactions. And some workers celebrated this decision, but some workers regretted it, saying that there was already plenty of minimum wage regular employment available if I wanted that. And now you've taken away from me the option of doing something different. So the interests are a bit divergent there. And then immigrants, very importantly, you mentioned immigrants. I think the fascinating point that's starting to come up is that so many platform workers, especially delivery workers, are in fact undocumented immigrants. So surveys, for instance, in Paris, led by Professor Laetitia Blanc, suggest that something like 37% of the workers are undocumented immigrants. And at least some of them fear that a presumption of employment would make it harder for them to access this type of work and push them to other types of black or gray market work. And at the same time, it seems untenable that some firms are able to benefit from employing undocumented immigrants. So these are some of the issues that I think we're grappling with.
Thank you, Vili. Clearly, I mean, it's a lot about trade-offs here, and indeed,
Yes.
one of the questions that comes in already from Theacaris is about this discussion and debate, and we always use the terminology, you know, flexibility, challenges and opportunities. But he's, I think, calling us into question here. Though for those excluded from traditional labour markets, this sounds a little bit misleading to talk about this as opportunities. Are exploitation, casualisation, no pension, intensification seen as opportunities? And I think that's the kind of trade-offs that we want to discuss a little bit here, because clearly there are what we, I suppose, maybe slightly disingenuously refer to as opportunities. There are, as you referenced there, some workers who do see these as an opportunity for them to work in a different way and don't want to be pigeonholed into traditional ways of describing these things. But maybe, Ignacio, I could bring you in then from the ETUC, looking at what the workers have to say about this. And clearly that very much is the input from the worker side, is that there's a fear of exploitation, of not being protected for the worker. Can you outline what the position here is, what you see as the challenges from the worker perspective?
Yes, thank you very much. Indeed, with pleasure. Well, we believe, the European trade union movement, that digitalization presents opportunities, and so do platforms. So we are not opposing to digital labor platforms, but we want them to abide to the rules. That is important. We even conducted a survey among trade union representatives, workers in platforms, and this was an overwhelmed reply from our members. So all the challenges which have been identified in terms of precarious working conditions, like low wages, no social protection, no prevention of occupational risk, unpaid idle time, they are associated with a business model which put all the responsibilities and the risk on the shoulder of the workers, whereas the benefits go directly to the platform. And this is something to be avoided. For us, it's a question of human rights, labor rights, but it is also in the interest of traditional companies who are abiding to the rules and the society as a whole. How do digital labor platforms operate this model? Well, basically they impose self-employment to their workers, bogus self-employment. A point of caution, not all the platforms are like that. There are good examples of platforms who are abiding to the rules, who are negotiating collective agreements with trade unions. And we are also very aware that there are a few digital labor platforms who are operating with genuine self-employed workers. And by the way, I should say that there is also a case of union busting in many digital labor platforms. So workers are being discriminated and prosecuted because of trying to build a collective voice. And in spite of this employers' hostility, we are very proud to see and to state in this seminar that there is a model of collective organization which is consolidated. Well, I wanted to mention now, because we are going to have the opportunity to talk about the directive in the second round, but there are two discussions which have been presented like a dichotomy. It's either flexibility or quality employment. Well, we are opposed to that. I mean, firstly, the flexibility which is provided to many workers to digital labor platforms is only whether to work or not. And flexibility can be achieved with an employment contract and can be regulated collectively. I mean, this has been the case for labor law and trade unions for already 2 centuries. And then there is a case with regards to migrant workers And okay, this means, but if you give me please 20 seconds, it is indeed the case that migrant and ethnic minorities are overrepresented in digital labor platforms. And while some platforms may indeed offer fewer barriers, this should not be at the cost of offering less rights and less protection. And then there is one thing. We are talking about ethnic minorities and workers with a migrant background. There is another thing, which is the gang mastering. We are talking about many workers who are undocumented third country nationals, and they are working with an account which is subcontracted by an individual, but the digital labor platform has also a role to play here. So it's also the liability of the digital labor platforms. We will discuss about what are the avenues for these workers we should be considered in the directive, but indeed they should not be let aside. Thank you very much.
Thank you very much, Ignacio. And I mean, I think you've been very measured here in terms of understanding that there are good examples of good platforms and how they have operated well, but then this issue of bogus self-employed, which really does need to be addressed as part of the discussion that we have about the proposed directive. But Isaline, if I could bring you in from Business Europe really to look here then at this aspect of flexibility that keeps coming up. You know, flexibility for whom? Is it flexibility for the employer only? Because we heard from Ignacio here that there is this issue that the platforms seem to be defining those as, you know, in a way which is perhaps not entirely fair or true. Can you talk to us a little bit from an employer's perspective? Do you believe that regulation is necessary, or can we actually manage to muddle through in a way that would allow this flexibility while at the same time giving it an opportunity?
Thanks, Mary, and thanks for the opportunity to be here as well. It's a great question, and it's one that's really reflected very well in the title of the webinar that we're holding here today, which is, of course, the Big Balancing Act, which is a title that I very much appreciate. And I think the colleagues that have spoken before me have also very well underlined that there is a great dichotomy between both the workers' wants and needs and the platform's wants and needs. And there is already a great differentiation within there. So it is very much a balancing act that we're trying to do here, whether it is through regulation or any other type of coexisting with the different platforms. I have to say that the initial proposal and the aim of the proposal, which I know we'll go into later, so I won't dwell on it, is something that we do very much support from the business side of things. But it is very much this balance that we are looking for and that we're missing in the current debates on the directive. But again, we'll go into that a little bit later. I can already say, though, that businesses, from our point of view, we deem it very crucial that any type of EU action on platform work supports not only the workers' rights, but also supports the sustainable development of this growing part of the economy. This was very well explained both by Dragos as well as Vili, that digital labor platforms across Europe really continue to rapidly expand and therefore also become a very key element in Europe's emerging economic landscape. We therefore are of the opinion that any regulation at the EU should avoid at all costs the stifling of this economic development of digital labor platforms, or also to undermine their ability to offer diverse works, forms of works or working opportunities, which reflect the freedom of choice of these workers, which was very well put, this dichotomy by Vili in his explanation on what platform workers actually want. I can also echo what Dragos said earlier, in that we need to understand that we're moving forward in our society towards a more flexible labor market that does not necessarily reflect the same realities as that of the 20th century, but where more non-standard forms of work, such as the platform economy, will become more prevalent and are also here to stay. So we need to really look into the future and prepare for that. It's therefore also crucial to make the best of these new forms of work, both in terms of economic growth on the business side of things, but also, of course, the access to employment and fair working conditions for the workers on the other hand. So we're of the view that any regulation on platform work should not be about regulating per se with a view of restricting this new type of work, but should be to provide clarity to the platforms and to the platform workers themselves on the applicable rules, on the one hand regarding economic development, and on the other hand with regards to improving the working conditions, of course. I'll also touch upon the fact that the platform economy is an ecosystem where diversity reigns. This is clear from all the research that has been done. It covers multiple business models, many sectors, lots of service provisions, and many types of different workers and worker profiles. It is thus a very complex reality, and we deem it cannot be reduced to a minimum common denominator, which we see is happening right now at the EU. So I fully agree with Ignacio in that relying on a digital labor platform as a business model can never be a vehicle to circumvent national labor law or misclassify workers into bogus self-employment. But I think we differ on who is in the majority here. The platforms adhering to the national labor laws and offering real forms of work, or the platforms who misclassify workers. So in the same vein, maybe my last point to end on in this first round would be to say that businesses, of course, want to ensure a climate of fair competition across all European businesses. And this is really of key importance to us. But I want to underline that creating this level playing field for all companies should really not restrict also the competitiveness of the European companies and the possibilities to do business inside as well as outside of the internal market. So we really see it as a significant concern for their competitiveness on the one hand, that this directive will create barriers for entry on the labor market as well as with innovation on the other hand. And this is in particular true for many smaller digital labor platforms who oftentimes don't have the voice in these European debates as the bigger ones do. That they will be the ones who will pay the price, of course, for any type of strict regulation at EU level. I'll leave it there, Mary.
Okay, thank you, Iseline. I mean, that's really very interesting. And I would like to bring in Vili in response to this, because you talked here about the dichotomy between the workers' needs and the platforms. And you referenced that also, Vili, earlier, but also about this diversity. So, you know, is there any possibility here, looking at the kind of diversity we're talking about, workers' diversity, the type of platform work, the type of work, right down to the way that this is represented in the algorithms? Vili, do you think there is a potential here to resolve this sort of dichotomy, or are we actually, you know, trying to bark up a tree here and we will never get an answer? I mean, can we reconcile this with the proposed directive, for example?
Thank you, Mary. Well, let me complicate it further first by sort of responding to a little bit both to Ignacio and Iseline. So Ignacio pointed out, you know, on this issue of flexibility quite rightly, that there is that flexibility and these low access barriers, they're legally entirely compatible with regular employment as well. And this is often brought up. And so people say, you know, we'd love to have both. Why can't we have both low access flexibility and protections of regular employment? The trouble is that's not business viable. So when platforms are able to offer these low access barriers and some flexibilities, precisely because they're not responsible for these people. And the moment you ask them to become responsible in the way of regular employer for things like sick pay and so on, they also then impose a greater control and greater vetting in terms of who they let in the first place. And it turns into a regular, more like a regular job, as we've seen in Berlin, for instance. And so it's a bit of a red herring to say, you know, we can have both. No, we can't. That's cakeism. We have to make trade-offs. But the Iseline, I would say, Isaline referred to the fact that, well, yes, freedom of choice. Like I pointed out, some people want protections of regular employment. Some people want this freedom. But actually, as a society, that doesn't mean we have to give them that freedom. We may be, in this case, we may have a case for being more paternalistic here, because if some people say, I want the freedom not to accrue pension savings and not to arrange any sickness cover for myself, it then falls upon society to protect them in any case when disaster strikes. So as society, we may have a right here to actually demand those individuals to save and take measures to protect themselves. Now, as to the question of, well, can we somehow overcome these contradictions within the framework of the directive? Well, I would point out to the fact in the directive that it, by Commission's own estimate, there was something like 28 million platform workers, although not most of them not full-time by any means. And the proposed directive, it would be estimated to reclassify only about 2 to 4 million of them into regular employees. So there's still the question of 25 million odd self-employed people. And just because someone is self-employed doesn't mean that they are well off and everything is fine for them. In fact, no, we know from research that self-employed people very often are very low income and poorly protected. And so one approach to dealing with this is to shift the conversation from employment status to rights that are afforded universally to everyone, regardless of what status they may be under. And this directive does do a little bit in that direction. It provides certain rights to everyone, regardless of whether they're classified as employees or not. Namely, the rights to transparency about algorithmic management, and right to have automated decisions reviewed by a human. And so one approach would be to say, well, let's move more of the weight of the directive towards these universal rights afforded to every worker, regardless of whether they're employees or not, and care a little bit less about that very high stakes on or off binary dichotomy. That's one way of trying to cross the chasm.
Okay, that's interesting. And maybe I can bring Ignacio back in on that. I mean, if we were to apply what Vili is saying here, Ignacio, and kind of focusing more on this universal rights approach, regardless of employment status, would that respond, do you think, to some of the concerns of the workers?
Well, thank you very much. I think that the proposal of the Commission is focusing on identifying the issue of the employment status, because that is the gateway to the access to all the challenges identified that we have been discussing before. And then we can have, of course, a discussion on the access of genuine self-employed workers to social protection. I mean, we have been working very extensively on that issue, of course. But I think that, I mean, considering the time constraints and the regulatory trend, which is quite advanced, perhaps it's better if we focus on what we have on the table, and I do not aim at being impolite here, please. I think that, the proposal of the European Commission is a good point of departure, but of course it needs to be improved. Firstly, because it includes a criteria that should be met in order to trigger the presumption of employment relationship. And here, I mean, there is a lot of perhaps interested misunderstanding on what a presumption is. The presumption is not the definitive reclassification of a worker as an employee or as a self-employed workers. Is what is the point of departure. And by adding this criteria, the Commission is putting a layer of complexity, which, by the way, is an infringement of a national definition of workers, to which we oppose. And then, well, the way the Commission is explaining how the presumption should be made operational, it's up to the individual worker to raise a complaint to an authority, and then, well, it is up to the authority to take a decision on whether this presumption should be triggered or not, and then it could only apply to that worker, to the fear worker who dared to present a complaint against the platform. I mean, considering the bargaining inequality between workers and companies, this is very unlikely to be happen. And what is actually the difference between what is proposed and what is already the status quo nowadays? And that is why, and by the way, but that is not a presumption. Actually, we are naming presumption to what is actually a shift in the burden of proof in the best of the cases. So that is why we believe that the point of departure should be that of an employment relationship. And we are not saying that from an ideological point of view. It's in order to respond to all the challenges identified. Court cases across Europe are also ruling in favor of reclassification of workers as employees, so we don't think that we are taking an ideological stand here. And in any case, this is the point of departure. Then the digital labor platform may have the opportunity to reboot this presumption of employment relationship, and this can be done in a very swift manner if there is political willingness, of course. We believe that the report of the Parliament is a step in the good direction at this regard, the report which was presented by the rapporteur, MEP Walmini. I mean, another debate is, well, all the amendments which have been tabled in block by the conservative forces with some remarkable exceptions. And then we have the proposal of the Czech presidency of the European Union, which basically is making everything difficult for any presumption of employment relationship, also very difficult for workers to be reclassified as employees, and well, it's also getting away with any collective rights of workers. Unions are totally off of the table. So it's actually going against not only the report of the Parliament, but the very core objectives of the European Commission. And one should not forget that we had the scandal of the Uber papers before the summer. So it would be interesting also to know to what extent an undue advocacy, lobbying strategy by unscrupulous digital labor platforms may not have influenced the legislative procedure. Thank you very much.
Thank you, Ignacio. And maybe just to go straight back to Iselin on that, you may wish to respond to one or two of the issues that were raised there by Ignacio, but also in terms of the elements that accompany the proposal with respect to the issue of collective bargaining. You know, how does the employer feel about those?
Thank you, Mary. As you can imagine, there's a number of points where I tend to disagree with Ignacio's viewpoint. So I'll just pick out a couple of them. Maybe just first to start with the court cases, the overwhelming court cases that you mentioned across Europe who are going in the same direction. I mean, I think we can debate on the same direction this is going in, but I think it's very important here to highlight that the overwhelming majority of these mentioned court cases look into the employment status of platform workers for in situ, so on-site platform workers, and not for the online platform workers. So there is a disproportionate focus really here in the global debate, or in the European debate, I should say, on the past misconduct of a handful of platforms. And yet this directive that is on the table aims to tackle all digital labor platforms. And I can even say here, we take issue with the proposed definition, especially in the Parliament's report, on what constitutes a digital labor platform, because this really broadens the scope beyond what is intended in the proposal for a directive, and aims to include a number of companies who are not digital labor platforms in the scope of the directive. I also just quickly want to go back on what Ignacio said with regard to the Council's compromise text, which was last week introduced. That apparently goes against the Commission's initial proposal. I would vehemently disagree with this. And I would actually say that it is, in our opinion, the European Parliament's draft report that goes in a completely different direction than the Commission's proposal. And I'll very clearly state why that is. Because the Commission's proposal had two key aims. very clearly. It was the improvement of working conditions for platform workers on the one hand, and on the other hand, it was the support for sustainable growth of platforms. Now, this support for sustainable growth of platforms has been completely removed from any type of discussion within the European Parliament. So this basically goes in a very singular direction without taking any regard for the consequences that this will have on the platforms. Now, like I said initially, we support the improvement of working conditions for platform workers, but going beyond this initial scope of the Commission's proposal will be completely detrimental to the platforms themselves. So I would very much disagree with the statement of Ignacio to say that looking into the specifics of the provisions that the Commission has proposed in its initiative is what the Council is doing, and going in a completely different direction and making it a very impossible and stringent directive to implement at the national level is actually what the European Parliament, according to us, is doing. I'll maybe just add one last thing with regards to the employment status. So with regards to the rebuttable presumption of employment, I am very much aware that the ETUC, of course, is advocating for a general rebuttable presumption of employment, since they claim that this would not infringe upon the competences of the member states to say who is an employee and who is an employer. But we completely disagree with this. Having a general rebuttable presumption of employment without any type of criteria would still very much interfere with the competences of the member states. So according to us, according to Business Europe, the only way forward that we see as viable is to not introduce this rebuttable presumption of employment. But to introduce maybe non-binding criteria that remain balanced, non-binding, as I said, and without any political bias in favor of either self-employment or the employment status of the platform worker. I therefore think it's very important to emphasize that the directive should leave it up to member states to define these criteria, both for triggering the employment status as well as for the rebuttal of the employment status.
And Iselin, just to quickly come back, we have a couple of inputs here. We have a comment more from Theocaras, who is saying that platform work as a successful ecosystem is not something that is supported in the literature from their perspective. And there's also a question from Social Justice, but perhaps as I bring Dragos back in, because I might ask him to respond to the social justice aspect, Iselin, you could just comment on the collective bargaining, and maybe Ignacio also, you might want to respond then to Iselin very quickly on it.
Yeah, sure, Mary, thanks. Well, we see that this is emerging in several member states, the collective bargaining. It is still, I have to agree with Ignacio there that it is still very much in its beginning stages. But I think it's important here to remember that the initial proposal for the Platform Work Directive was not a standalone proposal. This was accompanied also by a different initiative, which aimed to target the improvement of collective bargaining for self-employed people. So we tend to forget this in the conversation around platform work, but this is exactly what the Commission aimed to tackle therein. And so there are already provisions upcoming that will look into this. So I think we have it covered in that regard.
Okay, thank you. Dragos, just to pull you in here on the question from Social Justice here. Okay, it says platforms are making shameless profits. They should be obliged to provide sick pay and pension schemes. Can the EU declare a unified employment status and stronger protection against AI decisions? Now, that's a huge question, and I know you're not Solomon, but is there something that you could perhaps contribute here in terms of the overarching picture?
Sure, Mary. I think the question speaks very much to the dilemma that we have at the moment with regulating platform work. That is the short-termism that is implied in the platform work as a type of work versus the long-term social goals that we have as societies, basically. And I think when we regulate, or when we're trying to regulate, what we need to have in mind is these longer-term goals. Yeah, in Europe, we always talk about the social acquis. We're talking about the kind of all the body of social rights that we're trying to actually accumulate and continue to have and enjoy as societies, because we know that in their absence, this have tremendous consequences for the stability of our society. So that's the first point that I would like to make. And this speaks to the question itself, because what the directive itself is aiming to, and again, in a very narrow sense, as Isalin and Vili and also Ignacio have underlined, is to provide an employment status to platform workers, but to a very narrow segment of the platform workers, which is basically the offline platform workers, or the on-location platform work. Where the focus, therefore, would be to provide to this group of workers access to a minimum floor of social rights that involves your social protection access, healthcare, so on and so forth, pensions. So that those are the longer term goals, right? In terms of having let's say a broader, let's say European social security system, I think at the moment this is, to be honest, impossible. And that is impossible because the EU does not have responsibilities in these areas, right? In order to have that, we would need first to have, or European Union would need to have responsibilities or the power to tax people, right? And we do not have that at the moment. That will go much more towards a kind of a federal system that we see in the United States. Now, that doesn't mean that the EU itself does not try to preserve the social acquis that I've been mentioning in the beginning of my response, and we should not forget that the directive is part of a much broader body of regulations, directives, proposals, recommendations in the social area that the EU is pushing forward these days. And I mean, for example, the Council recommendation of access to social protection for the self-employed, the whole body of proposals that is included in the European Pillar of Social Rights, that tries to move our economies and our growth models towards something that is sustainable and something that is socially acceptable in the medium and the long term.
Okay, thank you, Dragoș, for that. And I'm going to come back to you all very briefly for a 1-minute takeaway as to what your main point would be from today's discussion that we could take forward. But in the meantime, perhaps, Vili, I could just ask you to respond, if you can, to a question from Jared Scullion, which is, does the draft directive mean that platforms and staffing companies that operate outside the EU, based in the US or the UK, for example, and organize work for individuals in the EU, that they may need to establish and pay tax in each EU country the workers are based in? Do you know the answer to that?
I think that's a question for a labor lawyer, to be honest. But I suspect that enforcement would be very difficult in many cases.
Okay. Well, I'm going to come back now to you, Ignacio, to take your top takeaway of today's discussion that you'd like to bring to the debate as we move forward.
Thank you very much. Well, it is clear, as shown by the scientific evidence, that digital labor platforms are extending to new sectors. They relate to both on-location and online digital labor platforms, and that is the reason why we need a future-proof directive. Because, I mean, we have already, according to the estimates, 5 million workers who are performing platform work more than usually. Even though we have observations, we believe that there are many more. And this is extending, according to the European Commission, to Eurofound. So we are talking about many workers who are perhaps currently working under good, established working conditions and protected by labor legislation. So these people need to be protected by labor legislation and the sectoral collective bargaining. We should not forget, by the way, that digital labor platforms do not operate in a vacuum. They operate in a sector of activity, and therefore they should abide to the sectoral obligations. And the last point is that one thing which is very positive of the proposal of the European Commission is that the the scope is tackling both on location and online digital labor platforms. I think that this was a very forward-looking step taken by the European Commission. Thank you very much.
Thank you, Ignacio. Iselin, can I ask you for your input?
Thanks, Mary. I think the discussions here today and the discussions that we'll probably be having in the future have underlined the complexity that is platform work and the directives that we're discussing here today. I think my main takeaways will be very much to underline again the necessity of the title that we're discussing here today, the Big Balancing Act. I think we would call for a more balanced approach to this directive. And to really make it clear, I think if there's one thing that I want to underline here today and I want people to take away with them today is that there shouldn't be a one-size-fits-all approach or a one-size-fits-all solution to this very complex issue. As we've seen the myriad of not only sectors that platform work covered, but the type of workers, the type of work. So it's really, it's a nuanced issue, and this cannot be solved by a general rebuttable presumption of employment, as I've stated before. And we really need to look into, as well as maybe my final point, we really need to look into what constitutes a digital labor platform to ensure that the crucial triangular relationship between the platform, the client, and the platform worker remains ingrained in any future directive that we have, to ensure that it is implementable, it is clear for the member states how they should implement it, and it is clear for both the platform workers and the platforms what rules shall be applicable to them in the future. Thanks.
Thank you, Iselin. Willy, your last input in less than 1 minute.
Thank you, Mary. Well, I think something that's really come up for me from this discussion is that we're not just talking here about the future of social protection for workers, because we're also talking about the future of collective representation of workers, really. Collective representation is essential for workers to be able to bargain with employers who are usually a more concentrated interest group on an even footing. And the shift from regular employment towards self-employment means that the established systems of worker representation are sort of becoming less and less relevant. And so then there is a desire for many people to sort of, for that reason, to return us or retain that established system of regular employment, that we don't lose that very important ability for workers to also collectively bargain. But if that's not going to happen, if we're not all going to be regular employees in the future, then we very importantly need to start thinking and continue thinking about, well, what does collective representation mean for people, self-employed people, and people in diverse sorts of employment? And also, as a practical thing, as we craft this particular directive, I think it's very important for policymakers to continue to listen to workers, including those who are not and cannot be represented formally. And I refer, for instance, to the undocumented immigrant workers.
Okay, thank you, Willy. And Dragos, to wrap us up, can you just take us through the next steps very briefly to say where we can expect the debate to go after we leave today?
Sure. I would just first to make a remark as summarizing the discussion. To me, the main point of the discussion that I would take home today is that, you know, regulating platform work is difficult, but I don't think it's impossible. There are some common grounds that we can find and that we can agree on that are necessary steps towards actually coming towards a consensus around the need to regulate platform work. Now, in terms of the next steps, we've heard that the European Parliament has been presented with a report, with a reaction to the Commission proposal. Initially, I think the timeline was suggesting that we would have a decision or a debate around this issue in the European Parliament in November this year. But I mean, given the complexity of the issue and given the kind of the very different positions that we've heard about today between the Parliament and the Commission itself, I think it will take a bit more time. So I think what we're looking at in terms of timeline is around a year or so until we will have a final agreement or a compromise around the directive.
Okay, thank you, Dragos. Thank you, Isaline. Thank you, Vili. And thank you, Ignacio, for your contributions today. I hope this has served to explore and shed a bit of light on some of the issues which we are facing with this particular debate. As we have mentioned several times, it is a balancing act, and I wish everyone well who is involved in this debate as it moves forward over the next phase. If you want more information on any of this, please do contact us at Eurofound. We have a podcast which we did with Dragos recently on platform work, highlighting some of the issues we've discussed today, and that's available on our website, but also on Spotify or various other platforms. We would ask you to continue to follow us, and of course, tune into our next Eurofound Live, which will be on the care issue, another issue to the forefront of the EU debate, in the background of the Pillar of Social Rights and the recent proposal for a new EU care strategy. Thank you all for joining us this morning. Thank you again to our panelists, and I wish you a very good day.
Thank you.
Thank you very much. Great discussion.